Well, good evening, everybody, to the Family Law Committee of Birmingham Law Society, Brexit seminar. And we produced this seminar for what we hope will be and promises to be a refreshing take on the complex subject of Brexit for family law, which will be happening at 11 o'clock this New Year's Eve. So the format for this evening, what do we have in store? As we're firmly in the festive season, I think it's fair to say now, we thought we'd inject some fun, or try to, into the complex subject of Brexit as the deadline for the Brexit transition period looms. Our speakers this evening are the Nosworthy brothers, Jonathan and Harry, whom we're incredibly grateful for giving up their time this evening. Harry and Jonathan will be contestants hosted by our very own Noel Edmonds, aka Mark Hans, who will be hosting Deal or No Deal Brexit for family law. And then to round off, we will have a Q&A session. So if anybody has got any questions, please feel free to post those in the Q&A chat function at the bottom of the screen. And please feel free to use the chat function as well. So to give some context for this evening, so then Brexit for family law, what does this mean? Well, as family lawyers, we've been urging our clients to consider issuing their divorce proceedings or their Children Act proceedings, particularly where their families have a connection with an EU member state. That is to enable them really to have certainty over which country shall have jurisdiction after 11 o'clock on New Year's Eve. We have been suggesting that the position is really unclear in terms of where cases are going to be heard, which will make forum shopping all the more interesting, and how a court order will really be recognised in another EU country. We've been also urging our clients to consider entering into nuptial agreements to really provide clarity over which country's rules will apply in the event of future dispute. For the remainder of 2020, people will be able to select which country their proceedings will be issued in accordance with Brussels II, ensuring the outcome to be recognised across Europe. It's a hugely complicated situation and will require us to work more closely than ever with lawyers in other EU states to protect our clients' interests. I'd like to go now to introduce our speakers. For those who don't know them, Jonathan, I think as the senior, for people who don't know, Jonathan is joint head of St Philip's Family Finance Team. It won't surprise you to know that Jonathan is ranked band 1 in Chambers and Partners Legal 500 as a specialist financial remedy practitioner with considerable expertise in dealing with very complex financial remedy claims. As many of us can testify, he is particularly adept in dealing with cases involving substantial assets, business assets, overseas assets, pensions and trusts. His clients include business people, professional sportsmen, barristers, solicitors, medics, accountants, farmers and the like. And Jonathan sits as a deputy district judge. Younger brother Harry is an experienced family lawyer at 4 Paper Buildings Chambers, who also specialises in financial remedy proceedings and private law children proceedings. Harry's expertise is in dealing with complex financial remedy claims, also including significant assets, company structures and offshore trusts. Harry was appointed a member of the research group that established the Family Law Arbitration Children's Scheme and was led by Alex Verdon QC in the first private law early neutral evaluation. Thank you once again to both of you for this evening. Before I hand over to our quiz master, Noel, again, if I can ask you to raise any questions in the Q&A, we'll deal with those at the end. If I can pass over to you now, Mark, for deal or no deal.
Thank you very much, Claire. Good evening, everyone. Thank you for joining us. For better or worse, Brexit has happened. As we know, the UK left the EU on the 31st of January 2020. However, practically, this may have gone unnoticed amongst the family law community. That's because we've been bound to the transitional arrangements, which will come to an end on the 31st of December 2020. Now, there are two main European instruments that we're all familiar with. That's Brussels 2A regulation and the maintenance regulation. These two EU instruments dictate how, when and who can commence family law proceedings, and they regulate and deal with enforcement and recognition of orders as between member states of the EU. I think it's important for me to highlight the UK's approach to negotiations with the EU. Their approach is set out in a paper actually called The Approach, published earlier this year. And what it says is the UK proposes continuing to work together with the EU in the area of civil judicial cooperation through multilateral precedents set by the Hague Conference on Private International Law and through UK's accession as an independent contracting party to Lugano Convention 2007. So whilst one suspects that Northern Ireland and fishing may be rather higher up the priority list than family law, I suggest as family lawyers we should be operating and working on the basis of a no-deal scenario and have a basic understanding of how the conventions might assist us as practitioners, both in the short term and the long term. We are conscious that this subject matter can be rather dry and that no doubt we are all feeling rather fatigued by the remote world. Therefore, rather than death by PowerPoint, in order to make it a bit more interesting, we thought it would be fun to identify the relevant issues by pitching the Nosworthy brothers together in an abridged version of Deal or No Deal, with me as the great Noel Edmonds. The rules of the game are simple. Each brother will take turns to pick a numbered box. Inside the box, there are random questions which the competitor will answer. The banker, who will call on this green phone, is a lawyer known to both brothers and has over 55 years' experience in the legal profession. He will give them a mark out of 10 for each answer. The winner, simple, is the brother with the highest score. I confirm that all the boxes have been sealed by our independent adjudicator. Jonathan, I can confirm, has home advantage and won the toss. Jonathan, please pick a box.
4. No. 3.
3.
No. 4.
The 3, you picked it now. That's it. Jonathan, does it matter whether a spouse issues divorce proceedings this year or next?
No, the answer to this question is it might do. It might do if there's a no-deal Brexit and the divorce is not purely domestic. 2 issues will need to be considered both sides of the New Year's Eve watershed. And they are, number 1, does this state, England and Wales for this purpose, have jurisdiction to deal with the matter? And 2, what is the appropriate forum for the dispute? As Mark said a few moments ago, the current arrangements, the Brussels II arrangements, will apply till the end of the year. After that, so far as the issue of jurisdiction is concerned, Brussels II will be incorporated into our national law. However, there will be some significant differences. Number 1, there'll be some minor changes in the precise language that's used when you're seeking to establish jurisdiction based on an applicant's habitual residence. This is unlikely to make a huge amount of difference, but do check the language of the new provision when you're seeking to found jurisdiction based on the applicant's habitual residence. And 2, as it stands at the moment, sole domicile is only available as a ground to found jurisdiction, providing no other grounds are available. This will change, and it will be possible to ground jurisdiction on the basis of either party's domicile. This could be a shot in the arm for the post-Brexit divorce industry. Goodness knows the country is going to need it. because people living and working in other EU countries may be able to petition here, even where the courts of the other EU state would have jurisdiction. So far as forum is concerned, as you know, as it stands, where this jurisdiction in 2 different EU states, the first past the post system operates, whereby the court first seized has jurisdiction. That process will continue to apply until New Year's Day. From the 1st of New Year's Eve, rather, from the 1st of January, this simple regime will no longer apply, and the forum's non-convenience principle, closest connection principles will apply as they do with jurisdiction and forum issues with non-EU states. Obviously, that's going to make cases potentially much more complex and expensive. The other point to note is that proceedings started before New Year's Eve this year will automatically benefit from recognition in other EU states. This will not apply after the 31st of December. It will not be a major issue with some EU countries which are signatories to the 1970 Hague Divorce Recognition Convention. However, some other important EU states are not included in that convention, including significantly France and Spain. This could be a big problem for some people because obviously divorce has an impact sometimes on tax, inheritance claims, legitimacy of children, immigration, nationality, and other things of that nature. So who should we blame for this mess? Well, I say Boris. Theresa May planned to put all EU law into the law of this jurisdiction and change it over time. This would have allowed for progressive, considered changes and may well have resulted in the EU taking a mirror approach. Boris, in his ultimate wisdom, decided that we weren't going down that road.
Jonathan, you scored a 9 for that answer, slightly over the allotted timescale given to you, so that's why you've got 1 point deducted. Harry, pick a box.
Good evening, Noel. Can I have box 7, please?
Box 7, will the enforcement of judgments in other EU states be different after the 31st of December 2020?
It's a very good question, Noel. And in short, yes, it will be. Practitioners may very well be aware that currently the EU maintenance regulation provides for quite an easy recognition and enforcement of maintenance orders amongst other EU member states. So if you had an order in England for maintenance, then that would easily be recognised and enforced in, say, Italy. However, after the 31st of December, that will cease to apply, and reliance will be on the 2007 Hague Convention or the 2007 Lugano Convention if the UK joins it. Now, whilst they're both similar to the EU maintenance regulation, there are some subtle differences. The 2007 Hague Convention does not have the same wide definition of maintenance as there is at the moment. Currently, maintenance is defined as any need-based award. So that could include pension sharing or a property adjustment order or a lump sum order. Under the convention that we're going to have, maintenance is interpreted in a much more strict way, as we know it as periodical payments. So for example, if you're considering advising a client to enforce an order against a property in another EU country after the 31st of December, it may be much harder to do that. The second significant point to bear in mind is that enforcement of an order will not be available at all where an order was made on the basis of sole domicile. So that's very important to check before you start pursuing enforcement. In terms of actually how to enforce an order in another EU country and the practicalities of that, at the moment it's really quite straightforward. But from the 31st of December, there's going to be a 2-stage process. So first of all, it'd be necessary to register the order in that country before you could then commence any enforcement process. So key things to consider are going to be take advice from a lawyer in that jurisdiction to see what their procedures are and timescales and costs. And secondly, if you've got a client in that position now, don't delay, issue your proceedings before the end of the year.
The banker was very happy with that answer. Harry, you got a 10 for that, so you take an early lead. Jonathan, next box, please.
I'll have 6. It's my lucky number.
6. Jonathan, will there be any impact on Part 3 applications?
Well, again, Noel, a fantastic question. And the answer is, assuming that there's a no-deal Brexit, the answer is yes. Because, as it stands, jurisdiction for Part 3 claims often falls to be determined pursuant to the maintenance regulation. From the 1st of January, this will no longer apply, and jurisdiction will be dependent on domicile, habitual residence, or in the case of the more restrictive provisions, based upon the presence of a family home in this jurisdiction. The removal of the maintenance regulations is likely to have 2 important implications. Number 1, in respect of pensions, and number 2, in respect of the ability of the court in this jurisdiction to make awards for maintenance as defined by the regulation under Part 3 following an award in an EU state. That all sounds rather complicated, but let me simplify it. So far as pensions are concerned, often or sometimes the issue arises because a foreign court cannot make an order which shares an English pension and which is binding on the pension administrators. Only a court in this jurisdiction can. However, it's not uncommon for a couple to have moved abroad after one or both of them has built up a significant English pension, but they have no other connection to this jurisdiction. As it stands, if they divorced abroad, whether or not in an EU country, they'll need to bring proceedings under the Matrimonial and Family Proceedings Act 1984 to get their pension sharing order. Absent any other connection to this country, such as domicile, currently they can use the catch-all necessity provision under Article 7 of the maintenance regulation. However, as I've said, this will fall away at the end of the year, and there is no equivalent provision in domestic law. This could mean that it would not be possible to share an English pension if you live abroad. So far as maintenance is concerned under Part 3, as Harry said, the issue of maintenance is widely interpreted under the maintenance regulation and effectively means need. There is currently doubt in this country as to whether a decision made in another EU state regarding maintenance would automatically preclude the court in this jurisdiction from exercising its discretion in this regard. This question was left open by the Supreme Court in the case of Adeji. However, the maintenance regulation falling away at the end of the year will mean that this doubt no longer exists, and presumably the courts will have unlimited discretion to do what they think's right in order to meet a party's needs under a Part 3 claim.
The banker liked that answer a lot, Jonathan. He's giving you a 10. Harry, pressure's on you. Pick a box.
Noel, can I have box number 5, please?
Box 5. Nice, easy one for you, Harry. Will there be any impact on agreements as to the choice of court?
Noel, another tea time teaser. Well, that's a very interesting question, and I think the short answer is yes, there is likely to be. Currently, litigants can rely upon the EU maintenance regulation to enforce agreements as to what court they choose to determine their disputes. So if you had an international couple who signed up to a prenuptial agreement and agreed that if they separated, irrespective of where one or other of them was going to live, if they decided England and Wales was going to be the forum where they wanted to settle their dispute, England and Wales it would be. But after the 31st of December, because the choice of court agreement isn't covered within the withdrawal agreement, there is no certainty in respect of that moving forward. The UK government has confirmed that they will respect choice of court agreements in other EU countries, but there hasn't been a reciprocal agreement from the EU 27. So it remains to be seen.
9 for you, Harry, from the banker for that question. So halfway through, we're neck and neck. Jonathan, pick a box, please. There's 4
I'll have
left.
one at the back. One at the back. What number is it? Can't see the number.
Number 8. Okay, Jonathan, a difficult one for you as a specialist financial remedy practitioner. Will there be any difference to the provisions protecting individuals from domestic violence?
No, well, I'd like to say I don't know the answer. But fortunately, I've done some research and I do. And again, the answer is maybe, depending on whether there is a no-deal Brexit and a non-domestic element to the case. Currently, pursuant to the EU protection regulation, protection orders, for example, non-molestation orders, made in any EU state are automatically recognised and capable of being enforced in any other EU state. And at the moment, that includes this country. This position will end on the 31st of December, and an order will only be enforceable in an EU state where an enforcement certificate has already been issued. In other words, issued before New Year's Eve. The position will be after the 1st of January will be different in this jurisdiction as against the rest of the EU, because in this jurisdiction we will continue to recognise and enforce domestic violence protection orders made in other EU jurisdictions, but the EU countries won't do the same. So if you have a non-molestation order, for example, that you want to rely upon after the 31st of December, you need to get a certificate now. If you don't, it will be a big hurdle potentially in order to get the order recognised and enforced in that other jurisdiction, and is likely to involve advice from a foreign lawyer.
Jonathan, the banker says that he can tell the last time you did a non-molestation order in front of the magistrates was 1996. So you're downgraded to an 8 for the answer to that question. Harry, pick a box. 3 left. You're in a commanding lead.
Can I have box number 12, please, Noel?
My former spouse wishes to move to Germany next year with our child. Will this create problems?
No, that's an interesting question, and in all likelihood, it may well do. Currently, Brussels II obviously determines the issues of the recognition and enforcement of orders relating to parental responsibility orders between member states. So currently, if it was agreed that a mother and the party's daughter are going to go to Germany, and the parties had agreed what the contact arrangements were going to be for the father, he could quite easily have that order enforced if it was accompanied by a certificate and an annex in Germany, as he would be able to in England. However, after the 31st of December, Brussels II will no longer apply, and the 1996 Hague Convention will. And there are some subtle differences. The first is that the Hague Convention allows for discretionary rather than mandatory rules to refuse recognition and enforcement. So it's going to be up to the member state, the country where you're trying to enforce the order, as to whether they exercise their discretion. Secondly, the rules of enforcement will take place in accordance with the rules in that country. So again, it's going to fall to the discretion of that EU member state. Thirdly, there's going to be an extra consideration under the 96 Convention that the best interests of the child are taken into consideration. And fourthly, there's no provision for direct enforcement of contact orders and return orders following a wrongful removal or retention. But as is the running theme, if proceedings are instituted before the 31st of December, then the terms of Brussels II will continue to apply.
Yes, fantastic, Harry. You scored a 9 from the banker on that question. Just one question left. 2 boxes, 2 questions, sorry. Jonathan, you need to pull it out of the bag if you're going to claw this back from the grips of victory of your brother. Which box?
Can I have number 4?
You can. have you got any practical tips for dealing with this changing legal landscape?
If I say no, I'm not going to get any points, am I?
Possibly not. The banker has been very harsh on you tonight.
So, in which case, I'm going to say yes. And the most important thing to bear in mind is that you should not bury your head in the sand and assume Boris Johnson will come riding to the rescue with a negotiated agreement that will keep things as they are. Boris flew over to Brussels last night and he had dinner with the EU negotiators. And the source, my best source of information, the Daily Mail, had this headline this morning. It said, "Give us a meal deal, Boris." Now, that suggests to me that Boris's conversation have had rather more to do with the quality of his turbot than rarefied issues of family law. So the best advice I can give you at the moment is consider taking action now, such that if you don't fancy your chances on a jurisdiction forum argument, then take advantage of the first past the post system that exists at the moment and before the end of the year. Don't worry about getting a MIAM if you desperately need to issue to ensure you don't breach the Brexit deadline. If you've got loose ends regarding pensions following a divorce elsewhere in the EU, get on and deal with it and don't wait until the end of the year. The same could be said with protection of domestic violence, protection from domestic violence orders required in the EU. Get a certificate now. There are also likely to be differences in the procedure for serving documents in the EU after the 31st of December. Make life easy for yourself. Do it under the current rules. Do it before the end of the year. And finally, if you find yourself having to issue, God forbid, between Christmas and the New Year, you need to take advantages of some of the current arrangements that have been put in place by the court service. And I would suggest in that regard, you study the Law Society and Resolution's guidance on issuing proceedings during that period of time very, very carefully, because they're extremely helpful.
Jonathan, the banker, loved it. He said he now realises why you are band one in Chambers and Partners. If he could give you an 11, he would, but he can't. You've got a 10 for that answer. He puts the pressure on you, Harry. Jonathan's on 37. You need a 10 to win, a 9 is a draw, an 8 is a loss, I'm afraid. Last box, box one.
Well, then I'll have box one.
What will happen next year when with the rules governing which member state has jurisdiction in respect of issues concerning parental responsibility for a child? So we're talking about jurisdiction in relation to private law children matters.
It's a very good question, Noel. Very good question. Well, Noel, as you'll be aware, currently when there's a dispute between member states concerning which of them has jurisdiction in respect of issues of parental responsibility, generally speaking, the country of habitual residence, pursuant to Brussels II revised, is going to have jurisdiction. But from January, Brussels II will no longer apply. And so practitioners really need to get to grips with the 1996 Hague Protection of Children Convention, which the majority of the other 27 EU states are signatories to. There are some key differences. Under the Hague Convention, the court can lose jurisdiction if a child changes its habitual residence during the course of the proceedings. Under Brussels II, they can't. Under Brussels II at the moment, where a child moves from one member state to another and acquires a new habitual residence, the court of the member state, which formerly had habitual residence, retains jurisdiction for 3 months. That is no longer applicable. And there are also some additional differences in respect of urgent protective measures that a state can take even when a child isn't habitually resident there but is present. So practitioners really need to make sure they're aware of the provisions of the 1996 Hague Convention to ensure that they're aware of what the consequences may be.
That concludes Deal or No Deal. The banker has scored you a 9, Harry, which means we have a tie. Okay. If we go to a tie, we're going to a tie-break question set by the banker himself. We'll just wait for him to dial in. Fingers on the buzzers, please. Who said in 2019 that a Brexit deal was oven ready? Jonathan, that's you.
Boris Johnson.
That's correct.
No.
Jonathan, congratulations. You have won the Brexit Deal or No Deal 2020. Harry, it looked so good for so long, but I'm afraid commiserations and back down to London for you with a sore head. But very well done to all of our contestants. On a serious note, I think that was absolutely brilliant from the two brothers. And I think that there were some really serious messages and clear and concise in there. But just please pick up the phone or drop an email if you are worried about anything to do with Brexit in the run-up to the final exit date. We'll always be happy. I know Jonathan and Harry will always be happy to try and help you as much as they can. So thank you very much for tuning in. And I'm going to pass back now to Claire.
Thank you very much, Noel. Thank you, Jonathan and Harry, for making sense of what is a hugely complicated area of law and putting it into context for us. It sounds as though our clients need to get their skates on within the next week to be issuing proceedings, or else thinking of enforcement certificates with any domestic violence, protection from domestic violence orders they get, and keeping themselves properly advised in the future. I'm just going to go to our Q&A, and if anybody has got any questions, they can still raise them on the chat or the Q&A function. Okay, and I can't see any live questions that have actually been raised. If anybody wants to talk, I can sort of join you to the tab audio, but it sounds as though we're going to be very busy in the new year in terms of certainly the prospect of people having international battles in terms of issue of proceedings, and the prospect really of uncertainty for clients having EU connections with member states in particular means that potentially it's going to be an uncertain time for clients, and we're going to have costly sort of international battles potentially. But as I say, I think now more than ever it's about getting in touch with lawyers on an international basis as well, which will make life ever more interesting for us. Okay, so I've got no open questions there. Okay, would anybody, Jonathan, Harry, would you have any further comments you'd like to make?
I think only to say that time will tell whether things become more certain next year, and I think one big implication across both financial and children work, where there's the international element, is going to mean that practitioners are going, as you say, Claire, to draw upon and take advice from foreign lawyers to see how other member states are going to interpret issues like recognition and enforcement, and to be armed with that advice before you advise your client over here.
Yeah, absolutely.
Or it might all be agreed.
Yeah.
Be no problem at all.
Yeah.
Yes, I think we'll be kept busy for a long time on this.
Claire, is it worth everybody noting that probably people have seen this already, but the HMCTS have extended the time in which you can file an application and when it will be constituted as valid service. So normally it's 4 p.m, but they've extended it to 11 p.m. on the 31st of December 2020. So if you file your application using the online portal, make sure you have evidence of filing it. Obviously, you won't be able to get the court seal, but you can show that you've lodged it at a certain time on the online portal. I wouldn't recommend leaving it till 10:59, but the option is open for those really, those really unique cases that we often get sometimes between the Christmas break. So I think that's a top tip for solicitors, really, is to be aware of that.
Absolutely, yeah.
With a big apology to His Honour Judge Rowlands, who may have to deal with those applications.
Yeah, the message is don't leave it to the last minute, like the self-assessment tax form. Things can go wrong. Okay, well, it just leaves me to say a huge thank you to our speakers, to Jonathan and to Harry for a really thoroughly entertaining and fresh look at Brexit, and for making, as I say, something that's incredibly complex make sense. It certainly did make sense to me, and just reinforces our need to get in touch and familiarise ourselves with the Hague Conventions, such as Protection of Children Hague Convention, and getting back to basics with technical black letter law, potentially. But thank you very much. And on behalf of the Family Law Committee and Birmingham Law Society, I'd like to say thank you very much for the donations that have been made by St Philip's Chambers to the President's Charity for the year, which is the Brain Injury Trust, chosen by Inez Brown, the current President of Birmingham Law Society. And thank you to the attendees on behalf of Birmingham Law Society. Just leaves me to wish everybody a very happy Christmas, and here's to a busy post-Brexit work for us as lawyers. Thank you, everybody.
Thank you.
Bye-bye.
See you. Bye-bye.
Bye-bye.